My name is Dick O'Mara. I'm a lawyer at Murray Pullman Murray in Portland, and a large part of my practice is related to dealing with education law. What I'd like to talk to you about today is having a dispute for a child who's been identified as in need of special education and related services. The federal and state laws provide methods for resolving those disputes when you can't do that informally at an IEPT meeting or in discussions held with the school administration, perhaps outside the meeting. It's always good at first to try to resolve your disputes at the meeting itself or by contacting the special education director or the superintendent after the meeting if there are issues. It's most important for parents to realize, though, that if there is an issue, you need to make it an issue. It's not well advised to agree to things at a meeting when you actually don't agree with them. So if you don't agree with something, the regulations give you the right, and you should exercise that right, to say, I don't agree. Now, in those situations, the IEP team process works with the administrator of the school having the right to make the decision for the team even when there's no consensus. And usually the consensus is broken because the parent or the person representing the child, if it's a guardian or someone else, is not in agreement with the team's decision. That's when the rights under the federal and state law will kick in and allow the parent or the guardian to bring a due process proceeding of one of the three types available. All of the three types in Maine come with an extra right, which is called the stay put right, or maintenance of placement. And that means that whether you file for a mediation or a state complaint investigation or for a due process hearing, the child's placement cannot change during the pendency of that proceeding. And that may last weeks or months beyond the time at which you start the process. So that would mean that if the school unilaterally is trying to make a significant change in the student's placement, the parent can block that change until the dispute resolution actually is resolved. And that's a very important right that parents need to understand they have. Unlike in most states, Maine extends the right not just to hearings, but to complaint investigations and standalone mediations as well. And so any initiation of due process can have that effect. Whether you choose a standalone mediation or a complaint investigation or a due process hearing will depend on the facts of your case and on the remedies that you're seeking. But in these kind of cases, the remedies are quite varied. You may be asking for a child to be found eligible who has been denied. You might be asking for changes to be made in the child's IEP. You may be asking for changes in the way the IEP is actually implemented. Even if the IEP appears to be correct on paper, in practice it may not be carried out in the manner in which the parent believes it should be. You may be asking for what's called compensatory education, which are services that are granted in the future to make up for violations that occurred in the past. And those can be done by either public or private providers, depending on what is worked out in the case. And you're also allowed to ask for reimbursement, assuming that you have paid for something for the child after giving notice to the district that should have been in the child's IEP. That's just an example of some of the remedies you can get as a resolution of a dispute you may have, and all of the methods, mediation, complaint investigation, and dispute and due process hearings that we'll talk about in other videos are means of arriving at those kind of remedies for the child.